A very good afternoon, everyone. So today we are going to discuss about something which is of trivial nature. Yesterday, judgment was pronounced by Tamil Nadu High Court, so Madras High Court in sense. So that was about a male will be jailed if he has an extramarital affair. So people who actually got to saw the news asked me like, is it even possible to jail just a male? So I just had one answer for them. You should get to go through the full judgment before you even tell whether this is right or not. Every Instagram page and even the LiveLaw clipping has been circulated in the social media, which creates confusion between the students whether is it only for men, what not for women. Aren't this rule biased? Some people tend to get confused whether this is a new law passed by the HC or is it something which is already in existence. That's when I thought to start a new channel and explain things about this legal rules, frames, and everything. So once again, I welcome you all for the Lord Denning's Law House. So here we are going to discuss about things which is going to be doubtful for the society, and if you are really interested in getting to know what the actual and factual point is, then you are at the right place. So coming to the judgment which was pronounced by the HC, this actually was pronounced yesterday, and this rule tells what is the judgment about and what not to be misunderstood by it. People just ask me like whether only men are to be sentenced when they had an extramarital affair. What about the women? Isn't this against the Constitution of India? After getting to go through the judgment, this is what I really found out. So this is a case by Nakkeeran at Jeroan Pandi versus a state represented by the Inspector of Police and Selvi. Selvi is the respondent here. So this case is an appeal case which was taken by the petitioner. It was confirmed by the lower courts and the first appellate court that the petitioner is to be sentenced. This wouldn't have captured the attention of the court if it was some other case. Even the petitioner would have not thought like whether this would become a trivial case or not. He thought like maybe if I don't like my wife, I can get to go with any other woman and nobody's gonna question me. But the petitioner wife, I mean, when it was filed in the lower court, the petitioner was Selvi and she is the spouse of the accused here. So the petitioner here stated that in the lower court that he had an extramarital affair and he tortured her physically and mentally. Now, when the judgment was pronounced by the first appellate court and also the jurisdictional court, it was stated that he is found to be guilty. The punishment for this case is 1 year of rigorous imprisonment, and for which the petitioner was against and he appealed in the High Court of Tamil Nadu. So let's get to see what are the facts that we should realize in this case. It regards the IPC section, Indian Penal Code, and the section which was involved in this case is 406, 494 and 5062 of IPC. The petitioner here stated that the husband had an extramarital affair and she is mentally disturbed very much and she wants to get a divorce. Though the divorce case is pending in the family court, she approached this court for justice. So herein we want to understand whether the judgment which was pronounced is right and it is valid. We as students of law and lawyers, we should understand, and even a common person from the society should understand whether this is right or not. So here is the fact of the case. The wife, Selvi, got married to the person, the accused. She was under the wedded life for almost 5 years. From 2000 to 2005 she was with him, and after 2005 she files a case for divorce and she sent a notice to the husband and she seeks for a divorce. Now this is brought under the section 498A of IPC section, and it is being brought into this IPC section stating that this is a mental cruelty which is being shown to the wife and this amounts to criminal offense. Not every case is brought under 498A. So, is it only the husband who is gonna be punished for having an extramarital affair? What about the women? So, if any spouse, be it a husband or a wife, if they find that his or her wife is having an extramarital affair or a relationship with someone else outside the marriage, then if he or she is a Hindu, definitely they can file a case on the basis of section 13(1) of Hindu Marriage Act 1955. Let me read the act for you so it would give you a better understanding. So the section 13(1) of the Hindu Marriage Act 1955 reads as follows. Any marriage solemnized, whether before or after the commencement of this act, may, on a petition presented by either the husband or the wife, be dissolved by a decree of divorce on the ground that the other party has, after the solemnization of the marriage, had voluntarily sex intercourse with any other person than his or her spouse. Second, has, after the solemnization of the marriage, treated the petitioner with cruelty, has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petition, has ceased to be a Hindu by conversion to any other religion, or has been incurably of unsound mind, has been suffering continuously on intermittently from mental disorder of such kind, and to such an extent that the petitioner cannot reasonably be expected to live with the respondent. So this is what the Hindu Marriage Act 1955 says. The petitioner here, Thamarai Selvi, could have filed it on the basis of Hindu Marriage Act in the family court. But herein, this petition, which is a criminal appeal petition which has come to the High Court, wherein both the arguments had been heard by the Honorable Judge. Herein, the judges have found few judgments which was quoted by the petitioner as well as the respondent. Just get to note the cases and go through it before you come to a conclusion. Manjuram Kalita versus State of Assam. KV Prakash Babu versus State of Karnataka. Manikam versus State of Tamil Nadu. Tahsildar Singh and others versus State of Uttar Pradesh. So these are some of the cases which was mentioned by the advocates who argued both on behalf of the petitioner appellant and also the respondent in this case. There were three angles which was presented by the petitioner Thamarai Selvi in the lower court, and both the first court and the second court confirmed that she is right and accused should be convicted. She not only filed the case against the accused and also the co-accused of this case. One probable point which we should really note is the respondent here, the husband, has submitted a birth certificate of the baby which was born between himself and the Dakshayani, the sixth accused of this case. So, considering this birth certificate, what he is about to say is that I have had an affair and I married the person Dakshayani in the year 2006, and she gave birth to a kid in the same year. The petitioner here, Thamarai Selvi, has left the house in the year 2005. So there is a gap of 1 year. But if we look keenly into this case, there was a 2-month gap wherein the husband has got into an affair with one another woman. Now, 498A does not attract in every case. It totally depends upon the fact and circumstance of the case filed by the petitioner. So it differs to case. Having an extramarital affair by the spouse does not attract 306 of IPC, but instead, if 498A is proved to be something which is trivial and which is gonna mentally affect the petitioner or the person who is filing the case, definitely it will turn favorable to them. So, at the end of the judgment, it is being stated that 498A is right and the petitioner is right in her point and the accused has to be convicted, and the court partially allowed this petition. The appeal case which was brought from the lower court, wherein the lower court has pronounced that the petitioner is to be sentenced and should also levy a fine of 3,000 rupees, on failing of which 6 months of simple imprisonment will also be levied on him. But one mistake which was made by the petitioner is that she said that there was a fight amongst them and it happened around the year 2014, and that was not true. When the petitioner was cross-examined by the counsel, she admitted that nothing happened of that sort. And also in the notice which was filed by the petitioner, she has stated that there was an issue going on between them, but they remained happy till the year 2005, right from 2000. So when marking the exhibit or the evidence, it was stated that there happened a fight between them. That was contradictory to the notice which was sent by the petitioner Selvi. So the court partially agreed it and partially neglected. The court also acquitted that the co-accused are to be released and only the petitioner has to be held guilty. Any judgment which is being pronounced by the court should be taken into consideration depending upon the fact of the case, and fact alone which stands till the end, and not even the law point is made into consideration when it comes to a case. So here, people who are reading these news should be very clear that they shouldn't come to a conclusion without reading the judgment. So this is impartial. So be it a woman or a man, they can file a case for divorce based on section 13(1) of Hindu Marriage Act of 1955, and not that alone. So this isn't a bias and this isn't a new rule or act which is being pronounced by the High Court. So we should get a better insight about the case before we conclude things. Let's get to meet in another video. Thank you so much.